Hello, everybody. My name is Jonathan Svitak, attorney with the Shannon Law Group, and welcome to another Shannon Law Group webinar. Today, we're going to be discussing SIRVA cases, kind of the ABCs of what makes a successful SIRVA case in the vaccine injury compensation program. I've got my assistant here, Brittany, who's going to be monitoring our chat. So if you have a question for me about, whatever, whether it's in this presentation or some other question about the vaccine injury compensation program or what we do here at the Shannon Law Group, I'd invite you to use this chat function and post your question, and I'll make sure to answer that when we're finished. So also, I hope everybody can hear me okay. If there's any tech issues on your end, feel free to message us and we'll see if we can get those sorted out. So without any further ado, I'm going to get started here. I'm going to share my screen. Okay. Let's see. Let's get back to the front here. Okay. So today, like I said, we're going to be talking about SIRVA claims in the vaccine injury compensation program. By far, the most commonly alleged vaccine injury in the vaccine injury compensation program. It's the most common injury that we see, at our firm during consultations. So we're very familiar with this type of injury. The court, obviously is familiar with this type of injury. And so, based on just our experience in the program, we know, what the factors are and that goes into making a good SIRVA case, and what the court looks for, what the government looks for when they review your petition and the medical record. So we're going to go over some of those things today. All right, so here's our agenda. First, I'm going to just kind of explain what SIRVA is. I think a lot of the people who are joining us today have either experienced a SIRVA injury or know somebody that has experienced a SIRVA injury, and they want to know how it happens. And want to know, how do I treat this type of injury? Will it ever get better? And what are some of my treatment options? And how do I pursue compensation for something like this? Because at the end of the day, you went in for a vaccine. This is the last thing that you were expecting to happen. So it's only right that you can take advantage of this vaccine injury compensation program. And so we'll go over how to navigate that program, how we can help you navigate that program, and then what kind of compensation is available to you if we're successful. So first, what is SIRVA? SIRVA is not really a medical diagnosis. It's a name that's been given to this injury, this phenomenon that is a shoulder injury related to vaccine administration. So the way that this happens is when you go in for an intramuscular vaccine, usually the person who's administering the vaccine, if they're doing what they're supposed to do, should be landmarking where to place that vaccine so that it is administered into either your right or left deltoid muscle. Now, sometimes if the person administering the vaccine either is improperly landmarking it, or perhaps they're going in at a wrong or incorrect angle, they should be going at a 90-degree angle. If either of those things occur, it can cause an injury to your shoulder joint. The most common thing that we see is a vaccine that's administered too high up on the arm, and it gets administered into the shoulder joint or capsule as opposed to that deltoid muscle. So instead of going into the deltoid muscle, the vaccine is administered into that collection of tendons, ligaments, or the bursa sac that make up your shoulder joint. And just the act of the needle or the injection into those components can cause inflammation of the tendons, ligaments, or bursa. And also, obviously there is the vaccine component of this too. So those kind of go hand in hand. The needle itself and the administration of the vaccine into the shoulder joint cause those tendons, ligaments, or bursa to become inflamed. And really, it's no different than any other type of shoulder inflammation case. You may have heard from sports injuries, like a torn rotator cuff. We have a lot of clients that have a torn rotator cuff after a SIRVA injury. So it works the same way. The only difference here is that it was caused by a needle. So I find this very helpful, this little explainer here. And I usually send it to my clients or somebody who's curious, about how this injury happens. But as you can see, there's the components there of the shoulder joint, and we've got the bursa sac, and that's right above where the vaccine should be administered. So, bursitis is the most common diagnosis that we see in a SIRVA case, and that's because, as you can see, the vaccine should be administered in this green area. This is the triangle that that if you're properly landmarking where to administer the vaccine, that's where it should go. If you're too high up, that's when it could be administered into the bursa sac. And then further into the shoulder joint is where you'd find the tendons and the ligaments that make up the rotator cuff and the rest of the shoulder joint. So if you're too high up, that's where you run into issues. Now, this can happen obviously with improper landmarking, and down here you can see what I mean by landmarking is the person administering the vaccine should be using 2 or 3 fingers to measure down from the top of your shoulder blade to allow that space, which is where the bursa sac is, where your shoulder joint is, and so that that you're administering under that landmarking, and you're going to be administering into the deltoid muscle. So that's one way to ensure that you're not administering the vaccine too high. The other way is you can see here it says tips to avoid SIRVA. Always sit to inject a seated patient. A lot of times we hear from our clients that they go in to see somebody for a flu shot. They have whether it's the pharmacist or the nurse or nurse practitioner have them sit down so they can administer it. And I don't know if it's to save time. The person administering the vaccine is standing, and it's really hard to get the right angle when you're not on the same level as the person receiving the vaccine. So whether you're standing or sitting, the person administering the vaccine should be on your same level. It's another way to kind of avoid this injury. We also hear a lot of times of somebody either pulling their shirt down to administer the vaccine, or something along those lines, where they use kind of the collar of your shirt to pull that down and administer the vaccine that way. Again, I think this is probably just to save time or make things easier, but really, the arm should be fully available to the person administering the vaccine. So much better to roll the sleeve up to administer the vaccine. If you're wearing long sleeves or you can't roll it all the way up to allow for the administration, you'd be better off pulling your arm out of the sleeve entirely so that they can do the proper landmarking and make sure they're administering it in the right spot. Finally, there can be an instance of the vaccine administrator using the incorrect needle length. Sometimes they use a needle that's too long. It goes too far into the shoulder. A lot of times, when we see this, we're talking about an injury like an edema, where maybe the bone was hit by the injection, or one of the nerves running down your arm, whether it's the axillary nerve or the radial nerve. So this is another type of SIRVA injury that we see. So yeah, really helpful explainer here. If you like, I can share the article that this is included in, and there's a lot of other information in there. I'd recommend that you check out. Okay, just want to make sure I'm admitting everybody. For those that have joined us a little bit late, this is being recorded, so it's going to be available to you. The whole presentation will be available to you at a later date, probably by next week. So treatment options. Let's say you have experienced a SIRVA injury. You went in for a flu shot. It was administered, and within the first 48 hours following the vaccine, you notice that your shoulder is very painful. You can't lift it above your head. You can't lift it or reach behind your back, and you're wondering, what's going on here? What's happened to my shoulder? If you get, if you're proactive and research this and figure out that this might be a SIRVA injury, it's better that you seek treatment sooner rather than later, and we'll explain why. But initially, what you might do is go visit your primary care doctor, report the injury to them. And, in my experience, it's hit or miss whether doctors are familiar with this kind of injury. Regardless of their familiarity with SIRVA, what they're initially likely to do is prescribe you some conservative treatment. So that would be anti-inflammatory medications or pain medications. And that's usually, the first step. For a doctor that might be more familiar with SIRVA, they might take an extra step and refer you to an orthopedic doctor, which, eventually most of our clients end up seeing orthopedic doctors. That's who treats joint injuries at the end of the day. So, but more or less the initial treatment options are anti-inflammatory meds, pain meds, rest, heat and ice treatment, some stretching, things like that. And, for a lot of people that think they, may have experienced a SIRVA injury, after a few weeks or a couple of months of some rest and some medications, their symptoms resolve. So, not every SIRVA case ends in, permanent restrictions or limitations or pain. A lot of them resolve earlier than 6 months. If anti-inflammatory medications, heat, ice, and rest don't resolve your symptoms, it's likely that your doctor is going to recommend a course of physical therapy. This is pretty standard. We've seen it with all of our clients, essentially, that have prolonged SIRVA symptoms. The first step is conservative treatment. So physical therapy, we're not going to, recommend a surgery just yet. We're going to look and see how you respond to therapy, how you respond to some range of motion exercises and stretches and some strength exercises. And, usually they'll do 1 or 2 courses of physical therapy. And you'll go back to your doctor after a month or 2, see if you've made any progress, see if, more therapy might be indicated. If you're not making any progress through therapy, or you feel like maybe it's even getting worse, the next kinds of treatments that your doctor or an orthopedic doctor might try would include cortisone shot injections, which is essentially to calm down the inflammation in your shoulder joint. Cortisone is not necessarily a healing mechanism. It's more of a pain relief type treatment. So a lot of our clients get great relief from cortisone injections. It kind of puts a stop in their pain. They're able to move their arm a little bit better. And some, for some of our clients, that's all they need is a cortisone shot or 2. And and it calms down the inflammation enough for them to get back to their daily life. For a lot of our other clients, cortisone shots, like I said, are kind of temporary. So, you might get 3 weeks, a month or so of relief, and then slowly the symptoms start to creep back. This is pretty common. And so, if you get to that point and your symptoms come back and they're just as painful and restrictive as they were prior to the injections, then your next option really is surgery. You could continue to do therapy, you can continue to do these conservative treatments, but it's more of a maintenance kind of situation where you're just managing the extent of your symptoms. Surgery would be the way to try to resolve them. And surgery is not for everybody. I'm not suggesting that every SIRVA case results in a surgery. If you continue to have symptoms, some people get to a point where they can live with whatever symptoms they have. They're minimal enough where it's not significantly impacting their daily life. And surgery is a huge undertaking. So I of course understand somebody's hesitancy with a surgery, but at a certain point, your orthopedic doctor, if you've had months or maybe even years of symptoms, that's just going to be the last resort is surgery. And there's different kinds of surgeries depending on what your diagnosis is. But we've seen everything from manipulation under anesthesia, an arthroscopic decompression, repairing a rotator cuff tear, and debridement when there's significant inflammation or thickening of your bursa sac. So these are all options, and obviously you're going to discuss these with your doctor and figure out what's right for you, depending on what your diagnosis is. Just going to double check and see if there's anything in the wait room here. All right, so you've gone through your treatment. You're still obviously dealing with your injury and the impact that it has on your life. You've incurred some medical expenses, whether they're co-pays or payments toward a deductible or treatment that's not covered by health insurance. You may have missed some time from work, or used some sick days or personal days that you wouldn't have used otherwise because of this injury. And obviously you've been in pain for however long you've been experiencing your SIRVA injury, and you're wondering, do I have any options? Can I sue the individual who administered me the vaccine? Can I sue the medical practice where I got the vaccine, or the pharmacy? Now, what we do is we file petitions for people in the Vaccine Injury Compensation Program. And we handle a lot of SIRVA cases. And the reason we do is SIRVA has been recognized by this program as a vaccine injury that occurs, and they know how it happens. They know what to look for, and if we can establish the criteria that they look for, there's a presumption that the vaccine caused your SIRVA injury. So that's the attractive part of filing a petition in this program, is that as long as you can meet the criteria that they set forth, we don't have to take that extra step to actually prove that the person who administered you the vaccine caused your SIRVA injury. And I'll get into that in more detail in a minute. Because this vaccine injury is a little bit unique in that it's caused by somebody that may have administered it improperly. There is obviously aspects of medical negligence or medical malpractice to this type of case. And there have been cases filed in state court, alleging medical malpractice on the part of the administrator, or on the part of the facility where you received the vaccine. We don't get involved in those cases. We prefer to file cases in this program. I think the compensation is comparable to whatever you would get in a state court. And the best part about this program is that you're not paying attorney's fees. So where you would likely be paying your attorney to file a case in state court, an alleged medical malpractice case. If you pursue compensation through this program, you're not paying your attorney anything. So there's some benefits to this program as it relates to SIRVA claims. And I'll go through how we establish that these are SIRVA claims and they're entitled to compensation. So if you go that route, first step is filing a petition alleging a SIRVA injury. So what we would do is, after our consultation with you, gather all the information we need to draft the petition, gather all of your medical records, prepare an affidavit for you and for any witnesses that we want to include. And we refer to those materials when we draft the petition and file the petition alleging a SIRVA injury. Once the petition is filed, we'll receive a case number, and the judge will be assigning our case to the program, and then ordering the Department of Justice attorney to file their appearance. Once we file the petition, we get the case number, we file all of our evidence. So we file the medical records, we file your affidavit, we file any witness affidavits, photographs, anything that I think is going to help us establish that you have a SIRVA injury. Once I feel that we've filed everything that we need to file and that the court requires us to file, the next step is filing what we call our statement of completion. If you're a client of ours, you may have heard me refer to this before, but it pretty much signals to the court and to the government, we've done our part, we've done our job, we filed a petition, we filed all the evidence, now it's time for the government to review the case. And one thing that I think it is tough to understand about this program is that it kind of there isn't a lot of back and forth between us and the government until we get to the point of really talking about whether they agree with us that this is a SIRVA injury or what your damages might be. The initial part of this process is we do our job, we file everything, then they take their sweet time doing their job, reviewing everything. Once they get to the point where they felt like they've reviewed everything they need to review, they're going to file what they call a Rule 4 report. And a Rule 4 report tells us what their position is, whether they are conceding that, yes, this is a SIRVA injury, or if they're disputing it for some reason, they'll tell us what their dispute is. Assuming for a second that they concede that this is a SIRVA injury, because we're going to be talking about successful SIRVA claims, an entitlement decision from the judge would be entered at that time. And that's the first phase of the program. The second phase is the damages phase. So determining the value of your case. And that's where we tally up all of your out-of-pocket expenses, any lost wages or lost earning capacity, and obviously pain and suffering. And the government will either make what we call a proffer, which is what they think the value of your case is, or we'll engage in some kind of settlement discussions. If we can't come to a resolution, we can have the judge decide that through either motions or a hearing. But this is the basic timeline of a SIRVA case. Okay. Oops. All right. So before we go into the factors of what makes a good SIRVA case, I just want to take a moment to discuss the eligibility requirements in this program. So not every vaccine that you would receive intramuscularly is covered under the Vaccine Injury Compensation Program. As of right now, COVID-19 is not covered under the Vaccine Injury Compensation Program. Neither is shingles, rabies, or the Pneumovax 23 pneumonia vaccine. The reason shingles, rabies, and this pneumonia vaccine, this particular pneumonia vaccine, aren't covered is, this VICP program was initially created to cover childhood vaccines. So, whatever you would receive as a child, all those vaccines are covered under the program. Now, obviously, as a child, you would receive the influenza vaccine, the tetanus vaccine, and some of these vaccines are administered to adults now. And so that opened up the program to, adult claims relating to the flu shot or the tetanus shot. But for the most part, any strict, vaccines that you would strictly receive as an adult aren't covered under the program. That's where you might want to, investigate a state medical malpractice claim or perhaps a, multi-district litigation case. I know that shingles, there's been a lot of litigation over shingles vaccines that you might be able to take advantage of. COVID-19 vaccines. We get calls probably every day from individuals who've been injured or think they've been injured by a COVID vaccine. At the moment, we aren't able to assist them in this vaccine injury compensation program. It's not covered. We're hopeful that at some point down the road, it's going to be covered. It's going through the regular process of getting covered, meaning, the vaccine is getting approved for, use in children. And just recently it was approved for children aged 6 months to 5 years old. So that's the first step. It's the first step of a very long process, though. We're hopeful that maybe, Congress might step in or some other government action will be taken to add COVID-19 vaccines to the VICP, sooner rather than waiting for this, sometimes 2-year process to unfold. So, it's a wait and see thing right now with these vaccines. Unfortunately, if you did, receive a COVID-19 vaccine and think that you have a SIRVA injury or some other type of injury, there's very limited options that you have right now. Whereas you might be able to pursue a case, in state court for shingles, rabies, or pneumonia vaccine, you wouldn't be able to for a COVID vaccine. There's been immunity for any administrator, any provider, any manufacturer of COVID-19 vaccines. It's been extended up until today. So your only real option at this point, if you believe you're injured by the COVID-19 vaccine, is to pursue a case or a claim through something called the Countermeasures Injury Compensation Program. I'm not going to get into that right now. We did discuss this at a previous webinar that I put on, and if you want more information about that, I'd invite you to check out our YouTube channel, and I go through the differences between these two programs and the requirements for that program. So please check out our page, and hopefully you'll find some answers there. You got to file your petition within the statute of limitations. We have 3 years down here, and it's 3 years from the date of onset of your vaccine-related symptoms. So for SIRVA cases, that's likely going to be either the day of or the day after you received your vaccine. So we to be safe, we usually say we're going to get your claim filed as soon as possible. We don't play around with the statute of limitations, but if you're somebody that this happened to, a few years ago, 2 years ago, and you're wondering what your options are now, I'd encourage you to talk to an attorney as soon as possible so that you're not bumping up to the statute of limitations. Finally, you've got to receive the vaccine in the United States. There are a few exceptions. If you are stationed abroad or work abroad and you receive a vaccine, you might be eligible. If you are a U.S. citizen and you receive a vaccine abroad and you return to the United States within 6 months of getting that vaccine, you can still file a case in the VICP. But for the most part, you've got to receive the vaccine in the United States to be eligible. Okay, so what makes a successful SIRVA case? Well, thing that is really kind of like the Bible for us and for attorneys on both sides in this working in this program is the vaccine injury table. And I'm going to show you what the table looks like in a second. But essentially it lists all of the vaccines that are covered under this vaccine injury compensation program. And then for each vaccine, they list conditions or injuries that are associated with that vaccine. SIRVA is associated with any vaccine that's administered intramuscularly. So whether it's tetanus, flu, pneumonia, whatever vaccine you receive, it's administered intramuscularly in your shoulder, then it's on the table. The table also lists the criteria that they look for in establishing that this is not just any shoulder injury. This is a SIRVA injury, and that includes the onset of your symptoms. So that's the first thing that we look for. For a SIRVA case to be a SIRVA case, the onset of your shoulder pain or range of motion issues or decreased strength should be within 48 hours of the administration. For many individuals, it's immediate. I hear all the time, during consultations that, this was the most painful flu shot I've ever received. So a lot of, people, when they experience a SIRVA injury, it's something that happens immediately. For other people, it may feel like a totally normal vaccine. And then over the course of the next 5-6 hours later that evening, you start to notice that your shoulder is very painful. You wake up the next day and you can't even lift it. So, there are some differences in onset for SIRVA cases, but for the most part, your symptoms should start within the first 48 hours. And one more thing about onset of symptoms, there's obviously whenever you receive a vaccine that's administered intramuscularly, you're going to have some pain or discomfort at the injection site. That's pretty normal with every vaccine that you receive. So there's got to be some kind of way to differentiate between that pain and more significant pain for a SIRVA case. So that's what we're looking for. Pain that's unusual, that's more severe than you're used to, and that doesn't go away after a few hours or one day. So that's how you kind of differentiate between those two types of pain. So the next thing that I look for in our cases is what's producing your symptoms. What's the reason you're having pain? What's the reason you can't lift your arm above your head or behind your back? And the reason for those symptoms should be a diagnosis involving inflammation of the tendons, ligaments, or the bursa sac. So I'm looking for bursitis, tendonitis, a rotator cuff tear type injury, frozen shoulder, or adhesive capsulitis, things along these lines. Now, this is why it's important to go see your doctor as soon as you can when you think you have a SIRVA injury. Not only is it going to benefit you from a treatment perspective, you're going to get treatment sooner rather than later, but also, it's going to help us establish the onset of your symptoms, and it's going to help us establish what your diagnosis is. And that's why, seeing an orthopedic doctor is also important, because, that they know, what your injury is and how to diagnose it. They can do a physical exam and based on some tests, determine, if you have an impingement in your shoulder, if you have bursitis, or if you have frozen shoulder. Obviously an MRI would be the best form of evidence for this. This is how we can confirm your diagnosis, but not all of our clients end up getting an MRI. So some of them, they treat with an orthopedic doctor. Based on his physical examination, he correctly diagnoses the injury, and they get some treatment for it without the need for an MRI. But at some point, it's somewhere in your medical records, we need to be able to reference, a diagnosis like this. Finally, this is for every vaccine case, every vaccine injury case, not just SIRVA. It's called the severity requirement. We need to show that you've had symptoms for at least 6 months. And that's not just taking your word for it. Unfortunately, I wish we could just file affidavits from people saying that I got my flu shot 6 months ago and I'm still having pain. The court and the government like to see medical documentation or medical records. So if let's say you're at 5 months of symptoms or 5.5 months of symptoms, and you saw your doctor and he said, keep up with therapy, keep doing exercises, and come back if you feel like you need to see me. In those instances, we encourage people to go back to their doctor if they're still having symptoms, after 6 months, because we're going to need that visit to show that there's still positive findings on your exams, you're still reporting pain, and things like that. So these are the three major factors that go into making a successful SIRVA case. If we can show these things, it means that there's going to be a presumption that whichever vaccine you received caused your SIRVA injury. So I'll get into that right here in the next slide. So I refer to the vaccine injury table. If you want, you can scan this QR code over to the left, and it'll pull up the link for the vaccine table. So I'm gonna try and see if I can pull up mine here too. Okay, hopefully everybody can see this. This is the vaccine injury table. This is what it looks like. Like I said, very, very important to the success of our vaccine injury cases in the program. As you can see, here's the vaccine column. Lists all the vaccines that are covered. Here's the illness or injury column, where it lists the illnesses or conditions that are related to these vaccines. Here's the onset column, which is when they would expect to see symptoms for that particular condition. So as you can see here, shoulder injury related to vaccine administration, SIRVA, they'd expect to see symptoms within 48 hours. It's true for every vaccine that's listed on this table that's received intramuscularly. So when we scroll further down is where we get into the qualifications and aids to interpretation. I'm not going to get too in the weeds here, but this is where they further define what SIRVA is and what they're looking for. So if we go down and we find the SIRVA, here we go, number 10, shoulder injury related to vaccine administration. Here's how the court defines what SIRVA is. And as you can see, it's an inflammatory reaction. It's an injury to the tendons, ligaments, bursa. It's not a neurological injury. So they have strictly defined this as an injury to the shoulder joint and not to any of the nerves, or not resulting in any nerve injury. Other things that we have to show for a SIRVA case: no history of pain, inflammation, or dysfunction in that shoulder prior to your vaccine administration. Now, there are limits to this. If you had rotator cuff repair 10 years ago, and you have basically without pain for 10 years, and you go in and get a flu shot and all of a sudden your shoulder, it's very painful. You can't lift your arm. That, it should not impact your SIRVA case or your eligibility. Now, if you had, a shoulder injury 8 months before this vaccine, and maybe you didn't have, a lot of treatment for it in those 8 months, but that's something where, that would allow for the government to point to that and dispute the case for that reason. So obviously there's some limits, but for the most part, we want to see that you've not had any issues with that shoulder before the vaccine. Now, this last section here, no other condition or abnormality is present that would explain the patient's symptoms. We usually don't see this objection in a SIRVA case unless there's, some prior injury, which was covered above. Like I said earlier, sometimes, some of our clients will have other injuries or conditions in addition to their SIRVA injury, maybe some neck issues, and a lot of times the government will try to say, their pain or their symptoms are related to this other condition. They have a neck strain and it's radiating into their shoulder. That's the reason for their pain or symptoms. So, if you do have some other condition or abnormality, that's why it's important to see, a specialist, to see an orthopedic doctor who can tell us these symptoms relate to the inflammation in her shoulder, not, some neck strain. So that's why seeing the right doctor, is important for us to establish, the criteria here on the table. Let's get back to the slideshow here. So, like I said before, the reason the table is so critical to the success of our claims is if we can establish all that criteria, we have what we call a table case. And in a table case, causation is presumed. So we don't have to prove that, this vaccine was administered in such a way that caused your injury. All we have to show is you got the vaccine that's covered on the program. The onset of your symptoms was within 48 hours of the administration. Your pain or your symptoms relate to some kind of shoulder inflammation diagnosis. There's no other reason, to explain your symptoms. And if your symptoms persist for 6 months, that's a table case. We don't have to get into, why or how the vaccine caused your injury. For an off-table case, we do have to take that extra step. So it's our burden to prove that the vaccine you received actually caused your SIRVA injury. So that would, that's where we get into that kind of medical malpractice perspective of, this type of litigation where we'd have to show that the way in which, the vaccine was administered caused this injury, which, would be difficult without, some clear evidence of how it was administered. So you'd have to remember, aspects of how it was administered. We would likely have to get an expert to come in and explain why, it was caused or why this happened. So it's much easier path to compensation if we can satisfy the criteria of the table. And for the most part, when I do my consultations, that's what I'm looking for. I'm looking for table cases. Every once in a while, we'll take off-table cases if we feel that we can be successful in that type of case. But for the most part, we're looking for table cases, and these are the questions I'm going to ask you during a consultation. Can we show this? Can we meet this criteria? Can we establish this? And if so, then I that's why I'd feel confident filing the case and feel confident in coming through for you. So it's a little background on the table and why it's so important. Okay, so let's assume for a second we're able to establish the criteria on the table. We have a table SIRVA case. There are no issues, disputes from the government's perspective. At least they're not raising any objections to it. In that type of case, the next step would be for the government to file what they call a Rule 4 report. And the Rule 4 report, like I said, is their official position. Most likely in a case that strong, they're going to concede that you experienced a SIRVA injury. So in that event, the next step would just be to move into the damages phase and start talking about how much compensation you're entitled to. If the government is not going to concede, if they're going to dispute it for some reason, let's say, a lot of times we'll have clients that maybe waited, 2, 3, 4 months before they went to go see a doctor after this injury. Totally reasonable for them to do that. I myself would probably likely do that if I didn't know better about SIRVA. But that gives the government an opportunity to dispute the onset of your symptoms. They'll say, if you're having pain or symptoms within 48 hours, you would have seen the doctor prior to 4 months after the vaccine. So it gives them, an opportunity to dispute the case. If, let's say, they dispute the case, we have some options to resolve it. We could settle with the government for a disputed amount, likely less than what you would be entitled to, if the judge were to rule on it. The other option would be to file what we call a motion for ruling on the record, where we just ask the judge to look at everything we've filed, look at all the evidence, and you tell us, you resolve this dispute between us and the government. You tell us, did we establish onset? Did we establish this factor? The attractive part about this motion is that it doesn't involve, a full hearing or testimony from our client or any experts, because scheduling hearings and getting a ruling from a judge after a hearing can take a very, very long time. So this is kind of a shortcut to getting an answer to that dispute. And if we can't resolve it, in either of these aspects, or if the dispute is complicated enough where a motion for ruling on the record really doesn't make sense, that's when we would proceed to a hearing. Hearings usually involve off-table cases because we have experts come in and explain why in this case the injury was related to the vaccine. The SIRVA cases, I would say, don't typically go to hearing, but if for some reason there was a complicated issue in a SIRVA case that required experts, that required our client to testify, that'd be the other way to resolve a dispute with the government. Okay, so we've made it through the entitlement phase, and we're into the damages phase. The damages available to petitioners in the VICP include any out-of-pocket medical and related travel expenses. So anything not covered by insurance, I ask my clients to do their best keeping track of everything. We, in the course of our representation, will request copies of your medical bills, and we can see a lot of times what was the patient balance, what was paid as a copay, or whatever was the patient's responsibility. But I always ask my clients to keep track of this on their own too, because there may be some things that weren't included in those bills that you paid for, like for instance a brace or a sling, something like that to help with your arm, maybe some over-the-counter ice heat treatments, over-the-counter medications, things like that, and travel expenses as well. So if you're going to therapy 2 times a week for 8-12 weeks, and you've got to drive 30 minutes, you can keep track of that distance. However many times you go, we'll calculate it, and you can get reimbursed for the mileage. And with gas prices the way they are today, I definitely encourage people to do that, to keep track of their travel expenses. Lost wages, earning capacity. So if you have to miss time from work because of this, not a lot of our clients do. They tend to work through this, type of injury. But if you have to miss extended time from work, we can request any wages that you missed out on, including if you had to use sick pay, a personal day, or if you took leave from work that you wouldn't have taken had this SIRVA injury not occurred, then we can calculate what the benefits of using those sick days or those personal days, and seek reimbursement for that. Earning capacity has more to do with if this is a permanent type injury. Let's say you have a SIRVA injury that's significant enough to prevent you from returning to the job that you had before the SIRVA injury. If you were, say, I don't know, a carpenter, or you built houses and you just can't do that anymore with the state that your shoulder's in, then we would calculate what you lost in earning capacity. The nice thing about these types of damages, medical expenses, lost wages, or earning capacity, there's no limits on those. So if you can't go back to your job, and you can't and you miss out on a lot of an income that you would have made but for the injury, there's no limit to what we can get. So as long as we can prove up what your earning capacity would have been over the rest of your life, then we can request that in reimbursement. Pain and suffering, on the other hand, is limited. It's capped at $250,000. For SIRVA cases, they're never going to be compensated at the cap. The most severe and significant SIRVA cases that involve multiple surgeries, residual symptoms, I've seen compensated up in the 200,000 range. But that's the highest we've ever seen SIRVA cases compensated. Most of them are compensated in between $30,000 and $40,000 to $150,000, $160,000, and that just depends on what we'll go through in a second here, some of the factors in pain and suffering. But it just depends on the nature and extent of your injury and the treatment that you receive. The way we resolve cases is either through a settlement and stipulation. So if the government is disputing your case for some reason and they want to see if you want to resolve it on a disputed basis, they'll offer a discounted settlement amount. Sometimes this is done in cases where there may be a good faith basis for a dispute. There's an issue with onset, or there's an issue with your diagnosis. And it may be the right move to settle it and stipulate to a kind of a discounted amount of your damages. So I tend to be averse to this type of resolution unless my client wants to do it. A lot of times this is a very lengthy process, and when you finally get to the point of hearing about settlement or an offer from the government, I completely understand wanting to take it and just be done with this. So that certainly is part of the calculation when you're thinking about this. If, like I said, the government concedes that you have a SIRVA injury, there's no disputes, then they'll make what they call a proffer. And a proffer is different from a settlement offer in that a proffer is they've looked at all the evidence, they've looked at your case, this is what they think it's worth. They're not budging. They're not going to send or offer a penny more than what their proffer is. So for us, it's a take it or leave it, kind of proposition. We can either agree that that's the value of the case, accept the proffer, or we can proceed with further litigation in front of the judge and have the judge decide. The judge is not going to know what the proffer was, so the judge could award above or below it. In most cases, the proffer is going to be at kind of the floor of what the value of the case is. or potential value of the case is. The government's done this enough. They know what these cases are worth. They're very smart about what they proffer. They make it just enticing enough to want to take, but also knowing that you may likely get more if you were to proceed with further litigation. At that point, again, timing comes into play. Do you want to wait a little bit longer through this process to maybe get some more money, or do you want to just accept the proffer? That's typically the kind of conversation that we have at that point. Finally, whether you settle it through a stipulation, you accept a proffer, or you go in front of a judge and he awards you compensation, at whatever route you go, there's going to be a judgment for whatever amount you agreed to or were awarded. There's going to be a judgment in that amount, and the judgment is basically an order to the government to pay you that in a check. And the check, these days is taking anywhere from 6 to 8 weeks to travel from the government to us. But the fastest way to get to that point would be to accept a proffer. A stipulation or a settlement has to get approved by HHS, whereas a proffer has already been approved. That amount's already been approved. An award from the judge is obviously going to take a little bit longer, because we've got to go through the process of putting on the case in front of the judge and having him reach a decision. So that takes some time too. But for the most part, these are the ways in which we get to a resolution. Okay, like I said, I want to go through, because what we're talking about at the end of the day here is what makes a successful SIRVA case. And we've talked a lot about the entitlement phase and what goes into making a successful SIRVA case from that perspective, establishing that you in fact have a SIRVA injury. But just as important is the damages phase. And what makes a successful SIRVA case is getting all of the damages that you're entitled to. So pain and suffering, there are factors that the court considers when they're determining what your compensation should be for pain and suffering. And for some of this, it's under your control, and you can kind of increase the amounts of pain and suffering compensation by doing some things, that can help you. So number one, the court's going to look at the treatment that you received. Okay. Now this is, in my mind, can be a little controversial, because, somebody could be having just as much pain, just as much, range of motion issues, and just goes about their day and tries to manage it, without treatment, as somebody who's actively treating. But, for what it's worth, the court is going to look at the person who is receiving treatment and think that that person should be entitled to more pain and suffering, because they were experiencing such symptoms that required treatment. They went in to get treatment. Otherwise, they're going to look at somebody that's not treating and think, well, it can't be that bad if they're not getting treatment. So, I have a problem with that. I know I've talked to my clients about this before. There's many reasons why somebody may not want to get treatment, especially over the last couple of years, especially with COVID. But there's also financial issues and insurance issues. But I've read enough of these cases. I've experienced it firsthand. The court is going to have a bias towards people who can show they've got treatment. So to the extent you're able to, go get physical therapy, go to your doctor, follow their treatment recommendations. If they tell you, just go home and do a home exercise program, then that's fine. You don't have to go and seek treatment that's not been recommended. And by no means am I suggesting go out and get a surgery if you don't want that. But that's something that the court is going to look at. Another reason why it's important is the next bullet point here, the severity of reported pain symptoms. So when you go in to see your doctor, a lot of times they're going to ask you, how are you doing? How's it been since I last seen you? And there's only going to be maybe 1 or 2 lines that they include in their medical records. It may even be just a number, 1 through 10 of your reported pain symptoms. But every time we were able to go in and reference that, let's say on this date he reported 5 out of 10 pain. On this day he reported 5 out of 10 pain, and for months he reported these levels of pain symptoms. It's helpful for us to point to that in the records. We can show the court he's been in pain for this length of time, for this many months of treatment. So that's another reason why going to get treatment when you can is good, because there's going to be references to how you're progressing with your symptoms. Just mentioned the next one, the length of time that you're reporting symptoms. So like I said, every SIRVA case is different. I've had a lot of clients that had barely 6 months of symptoms and pretty much full resolution of their pain. And then I have clients that have 14, 16, 18 months of symptoms and maybe still have symptoms. So that's obviously going to be a factor. And this comes down to kind of your pain tolerance or your capacity for treatment. But what I usually tell my clients is, as long as you're still having symptoms, I would consider every once in a while going in to the doctor and reporting them, because that then we can continue to point to those records. If you had 6 months of treatment, you still have symptoms, but you just don't want to go back to the doctor, you don't want to do any more therapy, the court may look at that and think, well, you'd reached a point after 6 months that you weren't really having any symptoms any longer. At least we don't have any record of any symptoms after that. So again, a little bit unfair to people, in certain situations, but certainly a factor that the court's going to look at. Here are things that you don't really have control over. Findings on a physical examination. So and MRI findings. Like I said, the diagnosis is going to be the diagnosis. But when an orthopedic doctor does a physical exam, they do all these tests. They're testing your range of motion, they're testing your strength, and those findings are going to be recorded in your medical record. So if you've got severely restricted range of motion, or you have significantly reduced strength, we can point to those findings in the records and say, look at all these times he went in for treatment and how many times he could barely move his arm. So those things are important. Surely when we go to establishing your pain and suffering. Same with MRI findings. Sometimes we've got very minimal findings on an MRI. Other times we have severe damage that's shown on an MRI. So, the court can sometimes get into a comparison, between cases with significant findings on an MRI versus, maybe more of a normal test of an MRI. So, again, that's not something you really have control over. And, to the extent I get questions a lot about, do I need an MRI? And although it's helpful for us to establish your diagnosis and maybe, can be a factor in pain and suffering, you certainly don't need to go out and incur the expense if your doctor doesn't think it's necessary. If your doctor thinks, it's going to be helpful either in establishing what your treatment should be or where to go next, then certainly, follow his recommendation, but you don't need to run out and get an MRI, right away, if you think it's going to benefit your case. So the last thing that we like to include in our cases are obviously our own clients' affidavit testimony, what they've been through over the last 2 years of this injury, the impact that it has on your life, the restrictions, either from work, hobbies, things like that. And we also like to include testimony of witnesses, family, friends, coworkers, anybody, close to our client that has observed them over the course of their injury. A lot of times I find that our clients, don't really like talking about themselves. I'm certainly the same way. I know there's a lot of our clients that aren't big, complainers. They're not going to, talk about maybe all the ways in which this has impacted them. So it can be helpful to hear other perspectives, hear from family members that can talk about how this has changed, their loved one's life. Coworkers, friends, neighbors sometimes have different perspectives that are illuminating. So we like to hear from those people too, because I think it adds certainly something for the judge to consider in a pain and suffering case. So these are, like I said, a successful SIRVA case is not just proving that you have SIRVA, but it's getting the compensation you deserve as well. So these are all things that we try to do, that helps us, and some things that you can, kind of do to help yourself. Okay, so I'm going to stop here just to see if we've got any questions in the chat. I don't see any right now, but certainly if you're listening and you've thought of a question you want to ask, go ahead and use the chat function, type it out. I'll kind of wait here and talk about a few other things for a few minutes in case anybody has a question that they haven't been able to ask yet. A couple other things here. We are coming out with another book. This one is just going to be focused on SIRVA. And we've got an exclusive offer for our listeners today and anybody that tunes in later. If you want to text SIRVA book to 312-847-2428, we will send you a free copy of the book when it gets published later this year. So it's in progress right now. We're working on it, nearly finished, and it's going to go over obviously a lot of things that I talked about today, but also include some other resources for you. So definitely check that out. And we might also have another book coming, but I won't spoil that one for you guys just yet. Some other things you can do, and if you're curious about either us or want some more information about the Vaccine Injury Compensation Program, you can follow us on YouTube. Our channel's Shannon Law Group PC. We also have a TikTok page. I'm sure I've been featured on that without my knowledge, but it's at Shannon Law Group. And we've got a lot of resources for you on our website too. We try and post blogs when we can. And we've been following very closely, this COVID-19 vaccine situation as well. Like I said, we're hopeful at some point that gets added to the program. So we try and stay on top of that as well. And then we've got other webinars that I've done in the past, and you can check those out on our YouTube channel. All right, so we've got a question here from Ryan Driscoll. How long is a SIRVA case typically take from initial filing with the court until the government pays the claimant? Okay, great question. This is probably, if I were to say there's a downside to the Vaccine Injury Compensation Program, it would be the length of time that a claim takes to proceed through the program. On average, from the time of filing until the resolution of the case, I'd say it's 2.5 to 3 years. Now, there are, obviously cases that resolve prior to that, and there are even cases that take longer than that, if you have to proceed to a very complicated or involved hearing. What we try to do is whatever we can control, whatever aspects of the process we control, we try and do them as quickly as we can. So, we put together your petition, we gather your records, and we file everything as quickly as we can. We file that statement of completion, as quickly as we can. But after that, a lot of it is out of our hands. It's the government taking their time to review the case. It's the government, to be honest with you, even assigning somebody to review your case. So that's where we've been seeing a lot of delays, especially over the last couple of years. There may be some changes coming. There's been some proposed legislation that would increase the number of special masters, which the judges, which may speed some things up, and ease some of this backlog of cases. But unfortunately, right now, to answer your question a little more directly, it's about 2.5 to 3 years. Let's see if we've got any more questions here. Okay. Not seeing any other questions at the moment, but if anybody has questions, you think of questions that you wanted to ask or you didn't have a chance to ask. Oh, let's see here. Okay, we got another question. Does a SIRVA case typically require the lawyer or claimant to spend out-of-pocket money that will need to be compensated later by the court? Okay, so trying to see if I understand this correctly. Maybe I'll answer it in a few ways. So there are costs that the attorney, will cover or incur in the prosecution of a claim in the vaccine injury compensation program. So we're going to, cover the filing fee. We're going to cover all the costs associated with gathering, medical records, any other evidence, that we need. And so those costs are going to be the attorney's responsibility. At the end of the case, the attorney, can petition for reimbursement of those costs. Similarly to the way you would be compensated if you paid medical expenses. You don't get reimbursed as you incur those expenses. You get reimbursed at the end of the case. You submit all of them at one time, and then you get reimbursed that way. So I hope that answered your question. I'm not sure if there was a different, you're looking for something else, but okay. Brittany from our office, who helps me put these webinars on, she does a really good job. She also monitors our YouTube channel, and sometimes we'll get comments or questions below our videos. So if you watch this webinar and you've got a question, you can even leave a comment on our YouTube channel, and we'll make sure to get to your question. All right, we've got a question here from Alex. In your experience, how does the government dispute a SIRVA injury claim made by you, and what relation do these disputes have to whether or not the case is a table or non-table case, if any? So essentially, the main disputes are going to be those factors that go into making a table case a table case. So the most common dispute is onset, usually, because a person who experiences a SIRVA injury isn't likely to go back to their doctor, within the first couple of weeks or months after the vaccine. And so the disputes are focused on onset. They're focused on, whether you have the right type of diagnosis. Rarely do we run into the issue of the severity requirement. Obviously, we're not going to file a case where the individual hasn't had 6 months of symptoms. So yeah, for the most part, what the government is trying to do is take our table case and make it an off-table case, because they know that those are much more difficult to prove. As far as how often does the government dispute a SIRVA claim? Well, obviously the goal is to make it impossible for them to dispute it. But at the end of the day, the government's job here is to defend the fund. There's a fund that pays out awards, for these injuries. They're defending it. So if they can find a reason to dispute your case, they're going to find it, and they're going to use it. Sometimes, they're splitting hairs. Sometimes, I question, whether they're acting in good faith, but that's their job. They're going to dispute the case when they have an opportunity to do so. So our job is to anticipate those disputes, and try and address them when we file all of our evidence. So if, let's say, you waited a few months to go in to see your doctor after you got your vaccine, what we'll do is look for other forms of evidence to kind of close that gap. Is there witnesses that saw you, that day or the next day that can talk about what happened? Is there maybe, did you take a day off from work, or did you report this to any coworkers? Did you message your doctor in a patient portal system or an email, and ask them, is this normal that I still have, pain in my shoulder? So we try to do our best to address any potential disputes. Okay. Right now, I'm not seeing any other questions. See, I still got a few people with us. So I'll give it another couple of minutes. If you want to ask a question, feel free. Otherwise, I'll be signing off here in a couple of minutes. The recording is going to be posted, like I said, shortly after this. And if you have any questions about this webinar, you can, like I said, post in the on the YouTube channel. If you have questions for me, if you want to talk to me, you can call our office and set up an appointment with me. If you're one of our clients currently and you want to discuss your case, obviously you're always welcome to call or email me, and we'll make sure that we answer any questions you might have. Our next webinar will be in a few months. Topic to be determined, but I'm sure it's going to be just as exciting as this one. So hopefully you guys can join us. Okay, no other questions. So that's going to be it for me. I hope you guys have a nice rest of your day and rest of your week. And I'm sure I'll be talking to some of you soon.